I'm glad to be here, and I'm glad to have everyone here as well, and welcome. So before we get too far into it, just wanted to remind everybody we've had great interest in our in-person presentation on October the 25th, a Tuesday, on error prevention. We've got Law Pro, Judah Straczynski coming. We've got Fritz Blaise, who's the innovator in residence from the OBA coming. We're having a big turnout, bigger than we even expected. So it's great. So if you're available on Tuesday, October 25th for a great in-person networking, see each other, have a drink, catch up, and learn something, please join us. So Ian, today we're talking about trustees' investments. Specifically, we're going to focus on really what are the authority, what's the authority for it, where do we find it, and sort of outline some of the basic information, and then we'll do a part 2 of this as well. So let's kick off. So the agenda for today is we're going to talk about just general investment obligations of an executor, and we'll talk about trustee and executor. They're in essence the same. You can consider them the same for today. We'll talk about some key requirements, authority for investments. Where does it come from? What's the history of it? What's our current statutory provisions? What about what the will says? How does that interact with our statutory provisions? And then talk about standard of care and mandatory considerations. So that's the idea. So Ian, any opening remarks on sort of
Sure.
basic investment obligations?
Sure, and this is a great topic. There was a sea change in the law of Ontario in 1999 when this came about. And I'm old enough to have been in the old system and in the new, so to speak. But this is one of those great topics that you know, I'm also a lover of history, and history matters. And we're going to go through this very carefully, because what informs us both before the change in 1999 and after, the history before it informs us how to manage it after, and also more importantly is that because there's no limitation period essentially with passive accounts, and complaints of investments can occur over the broad period of time, you might get into situations where you're actually dealing with the states and dealing with the issues of what the trustee investment rules are, both in the pre-1999 scheme and the post-1999 scheme. So history truly matters here, and I'm looking forward to going through this carefully with you.
Great. So we have, in essence, two basic obligations of investment, or maybe it's even one. I mean, it can be broken down to one. You can't just, as a trustee, sit on money in the bank or under, maybe under the mattress kind of thing. You have an obligation as a trustee and an executor to avoid wasting assets. So assets that aren't appreciating or aren't producing income. Now, all of that is contextual. I mean, not for every single day things have to be invested, but generally this idea that you can't just sit on assets that aren't appreciating or are non-income producing. You must generally invest assets. I just threw in here about the even hand rule. We're going to talk about that in our second part, but the idea that when you invest, you have certain rules about investing, and the even hand rule, well known, is this idea that when you have two different classes of beneficiaries, people who are entitled to income and people who are entitled to capital growth and capital, that you have to balance those two because they may diverge when you make investment decisions. So those are the basic investment obligations. What are the key requirements for any investment? Okay, so any executor's investment has to comply with two things. First of all, it's got to be authorized. What does that mean? Well, either the legislation authorizes it or the terms of the trust or the will authorize it. And where I say trust, read will. You can do both, okay? So it's got to be an authorized investment, but that is not enough. It also has to be an investment which forms part of the standard of care of a trustee in investing. And so it's a two-part test whenever you're looking at investment decisions. Ian, anything about those two key requirements before we get into them in more detail?
Yeah, no, I think just to be clear, the legislation where it's authorized, we're going to go through it in detail later. Is just so helpful. It codifies a lot of the guidance you need to be considering when you're doing this. So this isn't sort of airy-fairy general terms of art descriptions here. We're going to be able to get into the real nub of what is expected and required for the investment portfolios.
So I, like you, Ian, love history. And I want to talk about the history of trustee investments for a second. I actually want to go back. We had as you call it, I thought it was kind of a pun. I don't know if you meant it as a pun, a sea change in 90. If it was, then it was one of the great puns, but sea change in 1999. Well, we had a sea change in the 1700s. In essence. And the whole idea of trustee investments and executors investments starts here. So in the early 1700s in the UK, the government and a private company join forces and create something called the South Sea Company. And they're trying to get rid of government debt. And so they're trying to build this company. It's a private and a public partnership in essence. And what they do is they grant a monopoly over slavery to this company. This company is the sole company for shipping slaves to the South Seas and South America. And the buildup of this company, there's rumors about it. It expands. The values go way up, even though there is a war going on between Spain and the UK, and they can't access those markets as they were. And so this company actually has no real value, and it just expands and expands. The values go up and up and up, and then boom, in 1720, the balloon pops, and much of the wealth in the UK is lost because so much of it was invested in South Sea Company and other similar. And so the government enacts laws that creates a list of, because a bunch of trusts lost money, the government enacts a law that says we're not going to allow trustees to invest in these kinds of things. They've lost all their money. From now on, we're going to put strict rules on what they can do. They can only invest in government bonds. Originally, this is in the early 1800s. They slowly expand that to include certain corporate debt and securities, first mortgages, very limited GICs, very limited types of investments. Those were the only authorized investments. Remember, that's the first key point. Mutual funds, for example, were prohibited. So we have until 1999 what we call the legal list of investments. And that meant that because one of the requirements was that it had to be authorized, it had to be one of these types of investments. That was the only thing that a trustee could invest in unless the will said something different. It meant GICs, it meant treasury bills, it meant government debt, first mortgages, etc. That was the quote legal list, and that was the only ones that were authorized subject to the terms of the will. So that's the history there.
And the legal list, of course, prevails right to 1999 when the sea change in Ontario occurs with the prudent investor rules coming in. But the interesting thing is, I mean, you and I both, but I'm much older than you, but way
older.
I was involved in heavy litigation with Bre-X Holdings files where trustees are holding Bre-X, and most famously Nortel. And so the South Sea bubble, probably Shopify is going to be on the list now next, apparently. But there's just this is a never-ending cycle. So it's an intuitive list. When you look at the legal list, and again, this matters because sometimes your audits are subject to the period before 1999. The list itself, in the version of the trustee at that time, is a pretty intuitive list. As Jordy, you've described them. It's actually not it's not that restricted. It's actually pretty sensible, some of the parameters, and certainly that's why it lasted from the 1720s on, because of the sensibilities of it. But things got more complicated, which we'll talk about later.
So what do we have now, Ian? This is now post 1999, and as you said, we could still see many cases of law of passing of accounts from wills prior to that. But let's just talk about what we have now, which is codified, as you've said, in the Trustee Act. And I'm just going to turn it over to you for a second. I just have to take a quick. My son's calling.
Yeah. So yeah, this is really important, because the big difference between the pre-1999 and post-1999 is the concept of a prudent investor rule. And the prudent investor rule came out of the US. Before 1999, the US trust law allowed for balanced portfolio, prudent investor type investments for trustees, and essentially Canada finally caught up, and certainly Ontario finally caught up. But before you go to that's the sort of overreaching rule. Again, I can't emphasize enough, though, read the trust document, because the authority can be amended. And before 1999, people would jump up and down and scream and say you're outside the legal list in a case, and they weren't reading the document properly, because you were actually allowed to contract out of that, so to speak, in that sense. So read the will, make sure that you are not affected by the terms of the will of the trust. But the word prudent investor, as defined, set out in paragraph sub 2, is truly a term of art. And I've had the pleasure of deeply diving into what the term prudent investor really means, looking at the US experience and looking at the Canadian experience from a trustee perspective. So it is a true term of art that we have to be careful and be sensitive to how that is applied.
Yeah. So that's the prudent investor rule. And just to explain why 3 and 4 are in there was a case prior to 99 which said that you can't invest in mutual funds because that was a delegation of authority, that you were handing it over to the mutual fund manager to invest, and that was a delegation which was illegal, et cetera. So 27, 3 and 4 were just to cover that and say, look, that's not a delegation for the purposes of the Trustee Act. You can do it, and we don't count it as a delegation. It's like an independent investment of a security, for example. So that's why that's in there. So this takes us to exactly your point, Ian, which is, so what are, we got the statute, but as we know, there's 2 ways of authorizing investments. One is through the statute, and the other is in the will itself, and that's what we've got to look at here. And certainly, you said it was much more relevant when there was a strict list of what authorized investments were. Now, with the prudent investor, basically anything that's prudent could be an authorized investment, and so it's kind of less important. But certainly you should check your precedent, make sure that it doesn't refer to the legal list, et cetera. And we're going to go through a couple of instances of how the drafting might look and what its impact is. So when do you need an express of authorization in the will? And so you need it if the testator wants to allow the trustee to make that investment, and it wouldn't be authorized by the prudent investor rule. That's when it's crucial that it be in the document, because then it would otherwise not be authorized, and so we need it in the document. That's the first one. The second, and we'll talk some examples of that. The second, so basically, if you find a document that says, look, my trustees are authorized to make any investments that by law they're entitled to, that was typically just a way of incorporating the legal list. But what the Act says is that that's now imports basically the prudent investor rule. Thirdly, the Act does just because it says the prudent investor rule, and you can invest in anything that a prudent investor might invest in, does not authorize a trustee to do something that's inconsistent with the terms of the will. So you can limit, as Ian said, it's now more for limiting investments than where historically when we had the legal list, it was typically to expand it. Now you see it in wills to limit the types of investments. You might have a client, I've had clients, Ian, I bet you have as well, where they say, look, I only want my trustees to invest in GICs and treasury bills, right? Well, if that's what they want, I mean, they can certainly do that, and they'd have to put that in the will. And the prudent investor rule would not override that in a sense, right? And anything else, anything on those 2 points?
No, I think that covers it. I think we can move on.
Yeah, and the last point is Section 68 of the Trustee Act, which we don't look at too often, but basically it says, look, whatever we've said in this act, doesn't authorize something that expressly is forbidden to do, right? So that's the override. So there's a deference to the terms of the agreement of the trust or the will in every regard. Okay. So I'm going to give you an example of what might not work. Okay. So and this kind of turns to the standard of care. And I'm doing this to lead into that standard of care discussion. So here's the typical clause. This was in Groom Estate, and it had the typical investment clause. It said, you are authorized to make any investment that you consider appropriate, and it's not limited to authorized investments, and you're not liable for any loss, right? We've all seen this, right? And what does the judge say in Groom Estate? Because one of the defenses was, we don't have to abide by the requirements of authorized investments or anything else in the Trustee Act. And what the court said was these provisions don't override the duty to exercise the standard of care, in essence. And it's not Section 27, our prudent investor rule, which we're going to talk about, is not inconsistent with the terms of that will. And so just know that you can't just rely on this to get you out of a trustee's duty to meet the standard of care when investing.
And it's always a surprise to clients, and especially lawyers who don't practice in the area consistently, that these exculpatory provisions in your will really don't mean much. and then this is a perfect example. When someone complains about an investment and they say, well, come on, I was expressly allowed to do what I did. I got all these releases. What more you can do? Well, this is what judges do. They layer on the reality check of what is the standard of care.
Thank you for that. You're really smooth tonight. So here is the standard of care. It's 27.1. And it's not something strange to any of us. It's exercising the care, skill, diligence, and judgment that a prudent investor would exercise in making investments. So that is the standard of care. And so it's, again, bringing in, that incorporates the prudent investor rule, right? Now, the Act, fortunately, specifically identifies what a prudent investor would consider in making decisions, right? Rather than layering on, or at least leaving this open to case law, the Act is specific and says that a prudent investor must consider there are 8 items, right? So, and Ian, you've studied this a bit and seen how the US did it, because they often they created the idea of a prudent investor rule. Is that correct? As far
That's
as,
right.
yeah. And so many of these are sort of consistent with the evolution of the jurisprudence in that area.
Yeah, and it, like any good lawyer, you use this language. Take what they've put in the statute and use this language when you're considering if you're getting an expert opinion, or not an expert opinion, if you're getting an opinion from your advisor, or you're looking at defending your steps that you took on from the investment side, if you're being criticized. These kinds of descriptions are crucial, because They're actually, I mean, I went to law school because I can't do math and I wouldn't even know what's in my portfolio. I rely entirely on my investment advisor. When you've got nothing in it, you don't get very nervous about it. But the reality is that these are pretty intuitive expectations, but what a great codification to point to when you're in the defense mode of your decision making, or of course when you're in the process of trying to better understand what the prudent investor rule really means. And this is precisely the kinds of factors that you need to consider. And I mean, I don't think we need to read through them all because they're all on the screen, but I really, some of the more sort of obvious ones, obviously general economic conditions, but looking at the tax consequences of the decision is expected, and it's a must, and it's a pretty obvious must, because most of us, when we analyze our portfolios, get told by our investment advisors to look at what are the gains and should you take the gains in that year, and those kind of considerations. All of those things need to be looked at. So when I'm considering whether or not I'm being a prudent investor and meeting the standard, I'll expect my clients to look to getting advisors, not just the investment advisor, but sometimes they'll go and seek out tax advisors to also give some of the broad stroke parameters of some of the considerations they may want to look at when they're investing.
And so there's the overall philosophy is a more modern approach. So you'll see throughout the factors. I'm talking about number 4, for example. It's the role that each investment or course of action plays within the overall trust portfolio. So that's modern portfolio theory that says you don't just look at did this stock go up, and oh, you lost money on this stock, even though this one went up, doesn't matter, this is the one. That was the historic view of analysis. Now we talk about generally put the whole portfolio together, and you can't just look at each investment in isolation, which is what historically the model was. And so I just wanted to raise a couple of things. So obviously the total return is important. So not just looking at income, not just looking at capital, but generally what's going on holistically in the portfolio. Look at number 7. 7 is an important one because think about it this way. If you had an asset that if you were only concerned with growth and income or the general benefit of investment, then you wouldn't care about any particular asset being part of that trust. But there's often reasons why you want a certain asset, a family company that you grew. You don't want to liquidate that, even though you might get a better return. A cottage might be, not going up in value, but there's a need or a special relationship between the testator and the will and the estate and the asset. So that's contemplated in the prudent investor rule. And then of course 8 is every other kind of factor that you would be relevant to the circumstances. And that's right, Ian, isn't that where, and we'll talk in part 2 about liability, but that's where you can trip up, because you might consider 7 of them and then they turn to you and say the other side, well, why didn't you consider this factor? Right?
Yeah, and there's lots of exposure to that. I will say, just as a general comment, that it's really important to understand the parameters of the prudent investor rule, but it's at the end of the day, these cases are treated by the courts with the same respect that we all have to the fact that markets fluctuate. And so, you don't see a lot of litigation over the wins and loses because the Act says you don't have to look at it that way anymore. You have to look at it holistically. But you also don't see a lot of criticism on the investment side if you have touched on these factors in some demonstrated way. The courts are going to be very lenient on you. And we know under the Substitute Decisions Act, it's got its own parameters for investment. But there, if you're not taking compensation, you get a bit of a lighter touch in terms of the possible criticism by way of the statute. But here, if we're looking at classic trustees and trust and executors investing, I think we have to be comforted by the fact that if we will just follow these codified considerations, you're going to get the benefit of the doubt typically.
I agree. Obviously, that's true. There, you're not a guarantee of the markets. Otherwise, no one would ever take the role. And the last part that's really fundamental to modern portfolio theory is diversification. So, there's an actual overt obligation to diversify, and to the extent it's appropriate, considering the requirements of the trust and general economic and investment market conditions. So if you've got everything in one stock, the Nortel cases where everything was in one stock, one kind of investment, I mean, that's really why I think this was brought in. Oh, not only that, but also the whole idea that this is how people invest. They diversify and they recognize that reduces risk. So that's part of the obligation under the prudent investor rule. So there's those mandatory factors.
And you'll see diversification as being one of the first objections whenever you get into these fights. That's an easy one to pick out.
Yep. So next week, Ian, we're in Thunder Bay, so we won't be having this. We're really pleased to be going to Thunder Bay to speak to the Thunder Bay Law Association, and so we'll be doing that. So we won't be online next week. I did want to give everybody a quick. Let me just pause the sharing and do my full page thing, but. I did want to tell everybody of another feature that we have in eState now. We have something called nicknames. So many people like when they're setting up their documents, rather than repeating a full name every time, they like to include just nicknames, just a first name, for example. So that's what we have now as an option. When you set up your document, if you go to the names section, name options, there's nicknames. And if we include that, what it's going to do is it's going to identify the person and then give them a nickname, and then thereafter use the nickname. There are two places, just so you know, if you ever do use nicknames, whether you use eState or not, we don't recommend using nicknames in the appointment of executors, because your probate certificate is going to just say Marjorie is the executor rather than the full name. So that's why we don't put the nickname in executors. And same for funds and plans. So it's clear that for any financial institutions, who exactly the beneficiary is. So, so if you come across that and you're like, well, but it's repeating the full name again, it's doing it on purpose. But that's an option you can set up for each of your documents if you like the idea of short forms. So hopefully that's of use to some of you, and you might like that drafting tool. And we continue every week to build new features for eState users to make it easier. This, of course, is our short will that you can do a full will. This is pretty complicated with trusts and everything, and do it in a matter of 9 pages. So hopefully that's helpful. So thanks everybody. I hope to see many of you on the 25th of October for that in-person presentation. It's free. We'd love to see you. I think we're even serving some pizza and beer and wine. So if for no other reason than that, and I think Colleen, you're enjoying that's probably why you're signing up. I think it's the pizza mostly, but
it's the pizza. I've been working at getting the COVID pounds off. I was happy to be able to wear robes that actually fit today in court. So, but I will make an exception and enjoy pizza with you and Ian and Susanna and everybody else that wants to come. I can't wait.
Great. Thanks everybody. Have a great week, a couple of weeks, and then we'll see you again in 2 weeks. You can register. You can see where you can register. Thanks, Yannick, in our chat, and hope to see you all. Thanks.